Good morning, everyone. Welcome here this morning, early morning for us. This is meeting number 48 of the Standing Committee on Public Safety and National Security, Tuesday, December 14th, 2010. This meeting has been requested by 4 members of our committee. These 4 members have requested that we convene to discuss their request to commence clause-by-clause consideration of Bill C-23B, an act to amend the Criminal Records Act and to make consequential amendments to other acts. I am confident that our committee will want to entertain this request. Mr. McKenzie.
Chair, as I said yesterday, we would certainly move that pursuant to the motion being carried, the Committee of Public Safety and National Security shall immediately begin clause-by-clause consideration of C-23B.
All right. Thank you. Mr. Davies, are you still with us here? He had his hand in the air. Mr. Davies.
I was just adding my my name to the speakers list, Mr. Chair.
Oh, and it's your turn.
It's my turn? It
is.
Okay, so the motion's been moved, has it?
It has.
Okay, well, good morning, everyone. Mr. Chairman, as I think all members of Parliament, certainly all Canadians know, back in June of this year, the Parliament acted swiftly to make necessary and I think well-considered changes to the pardon system in this country. There were some relatively urgent circumstances, I think, that caused Parliament to act. In particular, two cases, I think, came to the public's mind. One was the imminent window period opening for the application of Karla Homolka to apply for a pardon, and the other situation that I think quite reasonably upset Canadians was the quiet pardoning of Graham James, who had been convicted of a number of sex offences against young men in his charge as a hockey coach. At that time, back in June, the government tabled a comprehensive pardon bill that I think contained some positive measures, but also contained some measures that not only required further study and careful consideration and deliberation, but also which I think some of which were on the face of it absolutely the wrong way to go in terms of pardon policy in this country. Back in June, Mr. Chairman, the New Democrats worked cooperatively and productively with the government and to fix the imminent mischief, I think, that was in the pardon legislation. In particular, we dealt specifically with the Karla Homolka and Graham James situations. We did a number of things, as committee members will remember, back in June. The first thing that we did, I think, that was very important was we fixed the problem that the national or the pardon granting institution had, which was they had very little discretion to deny a pardon if the application was made. Prior to our changes in June, there were two waiting periods, a 3-year period and a 5-year period, 3-year for summary convictions and 5-year for convictions by indictment. But if a person waited that length of time after they served their sentence, and by that I mean serving their full sentence, not only any period of incarceration, but also any period that may have been served on probation or on parole in the community, then provided that they had not reoffended in that time period, and provided upon a cursory police check that they had not, I guess that they had not triggered the attention of the police in any way, then really the National Parole Board the granting institution of pardons really had no discretion but to grant the pardon. So one of the good things I think that was in the government's bill back in June was a provision that would give the Parole Board the discretion to grant a pardon or to refuse a pardon in any circumstance that would bring the administration of justice into disrepute. So for the first time, I think, in Canadian history, we gave the tools to the board to deny a pardon in any circumstance in which that test was met. Now, it's been my view then, and it's my view now, that that tool is sufficient to deny a parole application, or a pardon application by Karla Homolka were she to make it. I think it also may be broad enough to empower the board to refuse to grant a pardon to Graham James were he to make that application today. So we did that. That's what Parliament did through all-party cooperation, including from the New Democrats. It was also our suggestion, the New Democrats' suggestion, to add manslaughter to the list of offenses that would require someone to wait 10 years to get a pardon. We might also remember that back in June, the other important measure that Parliament took was to increase the time periods that offenders had to wait to get a pardon in certain types of offenses. We took sex offenses against children and increased the time period to wait for a pardon from 5 years to 10 years, and for summary conviction offenses from 3 years to 5 years. At the same time, as I said, what the New Democrats insisted upon was that manslaughter be added to that list of offenses for which a person would have to wait 10 years. And we did that specifically because that's the offense that Karla Homolka was convicted of. Now, I want to pause here and just talk for a moment about something else that's important. The former Minister of Public Safety, Stockwell Day, back in just I think it was 3 or 4 years ago, reviewed the pardon system. The government did a review of the pardon system. At the time, Graham James was in the news, and in fact there was another sex offender, I believe, that was in the news at that time that spurred the government to do a review. And the government did a review of the pardon system and made very, very minor changes to the system at that time. So we have had a review, I believe that was in 2007, if my memory's not mistaken. And then we reviewed the pardon system in a very in-depth and profound way in June of this year. Now, I think that that all-party cooperation in June produced a very important and progressive development to our pardon system. It gave the pardon system the opportunity to refuse to grant a pardon and gave them the discretion. It ended what Canadians have always perceived as a rubber stamp. That's what they call the rubber stamp, that if you wait the 3 or 5 years as it then was and you make your application, pretty much the pardon was automatic. What we did is we fixed that problem by putting the discretionary aspect in. We also, I think, addressed something that Canadians had a great concern was, which is 3 or 5 years a long enough period of time to wait for someone to apply for a pardon? In many cases we thought, no, in a lot of cases, particularly sex offenses, we should make an offender demonstrate a longer period of rehabilitative behavior, and that being 10 years. And that, I think, also was a positive step. I'm going to get into this in a few moments, but we've heard some testimony before this committee that if a person's going to reoffend, they do it within 5 days or 5 weeks or 5 months. If someone actually has not reoffended for a period of 5 or 10 years, then the evidence that we've heard so far, and I'm going to get to this, I think we need to hear more evidence on this, is that it is highly unlikely that that person is going to reoffend. So here we are today. This government has come back this fall and put in what I think are some further proposals to change the pardon system that are worthy of merit and further careful deliberation. And I think they also, it's fair to say, have continued to pursue some of the flawed aspects of the bill that was presented in June. And that, of course, is the bill before us, Bill 23B. Now, whereas C-23A in June, as it's now known, made the necessary and important changes, what we have left in 23B primarily are some issues that we must, I believe, tread very carefully on. When we haven't made any pardon changes in decades in this country, when this government looked at the pardon system in 2007 and thought that it didn't need any changes at all but a couple of minor administrative changes, when Parliament has made important changes in June, there is no need for urgency at this point today. But we've had only 3 hearings so far. We've had 3 days of hearings. Now, for any of the Canadians watching, what 3 days means, it doesn't mean 3 full days. It means 3 meetings of 2 hours apiece. And in that 2-hour period, we have had 15 minutes carved out for dealing with committee business. So we have so far, it's fair to say, maybe about 4.5 hours of discussion and hearing from a few witnesses on the issues of pardons in this country. Of the 2 hearings that we heard actual witnesses, and we only heard from a handful of witnesses, I think it's already quite clear that this bill has been exposed as having some serious deficiencies. Some would call it deep flaws. And each time a flaw is exposed, I think it causes us to, as parliamentarians and as policymakers, to stop back and think we better move carefully in this area. So we're just getting started studying this bill, and it's obvious that there's many problems to be dealt with. Now, instead of hearing that evidence, the government here wants to shut down testimony and rush through this bill without having the necessary and careful deliberation. And that, in my submission, Mr. Chairman, is not a responsible way to deal with a very serious issue. Now, I want to talk about one of those major flaws. This government has put in this bill, they did in June and they're coming back with it here, what's called the 3 strikes and you're out rule. There's a provision in this bill that says that anyone with more than 3 indictable offences would be ineligible for a pardon forever. I'm going to say that again. You get more than 3 indictable offences, and the Conservative government wants to pass pardon legislation that says you will forever be ineligible, barred from receiving a pardon. Now, the New Democrats arranged to hear from a few of the people that would be most affected by this, and that's some former offenders who would be denied pardons forever under this proposed legislation. These are people who have had more than 3 indictable offences, and they came and they testified right here at this table before this committee. We also heard, of course, from organizations that work with ex-offenders, and here's some of the things that we've heard so far. We've heard that proceeding with this provision hastily might actually endanger public safety. And that's because we've heard some evidence, a little bit so far, that shows that the pardon system and the pardon process is one tool in the rehabilitation process. But it's a very important tool. We've heard from people who work with offenders and offenders themselves that having the prospect of getting a pardon, to be able to work towards a pardon, helps them to get their lives back on track and not reoffend. If there is one overreaching goal in the carceral system that we should be working towards, that all parties should be in agreement on, it's that we should always be supporting and favoring policies that help offenders not reoffend. Not only because it's good for the offender and their families, but because it's good for our communities. But because when that person goes back in the community, I want that person to not reoffend and not endanger any other family, any other person, any other property. I want our people to be able to walk safely in our communities. And that means I, as a parliamentarian, will take very seriously when I hear from people that tell me that a particular measure helps them not to reoffend. This piece of legislation, this particular provision of the bill, the 3 strikes and you're out bill, would endanger that principle. It will take away one piece of hope, one piece of motivation, one piece of policy that we have already heard a taste of evidence is instrumental and helps people in not reoffending. So we've heard the valuable role that pardons play in improving community safety. We've also heard that in testimony from department officials that 25% of the applications that have been received for pardons are from people who have more than 3 indictable offences. Now, when we say more than 3 indictable offences, I'm sure Canadians react the same way I reacted when I heard that, which is, holy mackerel, someone who's got more than 3 indictable offences? Wow, that person shouldn't get a pardon. That's what I thought. Until we actually started talking to people who actually have experience with this process and from former offenders themselves. And again, we put 3 live human beings in front of this committee, only 3. Out of the tens of thousands of people who may be affected by this, we put 3 people, we've heard from 3 only. And we put them here to be subjected to questioning from our side and from the government side. What did we hear? Well, we heard from one person who was convicted of, I think, 24 indictable offences, which sounds horrible until you hear his story. And the story that we heard is that these were convictions for selling steroids. We heard that this is a person whose wife passed away from cancer as a young married man. He had a mortgage, and he went into deep grief. He had financial problems, so he started selling steroids. He told us that one transaction of selling steroids would result in multiple convictions: possession, trafficking, conspiracy, fraud. So what sounds like a person who's got an intractable trend, an irremediable criminal, is actually a person who sold steroids over a period of 6 months and ended up with 24 indictable convictions as a result, because there's multiple convictions from single transactions. And who is he now? I hope Canadians actually saw this man. This man has gone years without reoffending, and he's now an executive in the media industry, someone who's got a mortgage and a new marriage, and who occupies a position of responsibility and one of probity. This was a person who presented an absolute success of what happens when the prison system works in the right way. This was not a thug and a hooligan or the type of criminal that the government likes to portray, the stringy-haired, criminogenic monster that the government likes to hold up as the model for all of their criminal policy. This was a real person who had, for a brief stretch of his life, a problem, and he has put his life together back in admirable fashion. Second person we heard from was a young Aboriginal man, and we all know that Aboriginals are terribly disproportionately represented in our criminal justice system and in our prisons. This person told us that he's a recovering alcoholic who committed offenses that were property offenses. Yes, they were serious. I don't mean to minimize the offenses. He committed robberies. And he himself said that he knows the pain and the fear that he caused when he went into stores and robbed those stores. But he also is a person who has gone years without reoffending. And he's a person now who has got a family and children. And he talked about how he wants a pardon so that he can get a better job so that he can support his family. All three individuals talked about how getting a pardon is an incentive for them and a very important part of their rehabilitation plan to help turn their lives around. Now, even, I dare say, some of the Conservatives' own witnesses, and I think people who have a lot to tell Canadians about the criminal system, and that's the victims groups. We heard from Sharon Rosenfeld and Sheldon Kennedy, two people who have suffered at the hands of criminals in a way that none of us can truly understand. Ms. Rosenfeld lost a child to convicted killer Clifford Olson, and Sheldon Kennedy, as a young teenager, suffered under the sexual offenses of his coach, someone under whose charge he was put, who should have been caring for him and who should have been watching out for him, who violated that trust. And we have to take their testimony seriously. And we heard from both of those individuals that neither of them, I don't think, would terribly be in favor of removing the possibility of a pardon from someone forever just because they had more than 3 indictable offenses. Now, we heard testimony from the minister himself that the figure 3, more than 3 indictable offenses, was an arbitrary one. He said, when we asked him, well, do you have any data to support the number 3? Is there some data to support that someone with more than 3 indictable offenses is somehow less prone to qualify for pardon than someone with 2, or is the magic number 4? And his answer was surprising and I think very disturbing. It just seems right. He has no data, no empirical data. 0. This is someone who's got the resources of the Ministry of Public Safety, probably the Ministry of Justice, who's got the full resources of government to provide studies and data and facts, who came to this committee and said, no, I got nothing. 3 just seems right. 1's not enough, he said. 2's not probably right, but 3 seems right. Mr. Chairman, that's Goldilocks policy. That's making policy like children do. Well, this one's too hard, this one's too soft, that one's just right. This policy would preclude Canadians, tens of thousands of Canadians, from ever getting a pardon for the rest of their life. And it's based on a feeling, a hunch. That's not the way to make carceral policy in this country, and it's not, I think, what Canadians send us to Parliament to do. I think Canadians send each and every one of us to Parliament to carefully consider facts and evidence, to take the best, to make the best effort we can make to come up with policy that is thoughtful and effective. Again, Minister admitted no evidence, no data, no studies to show how adopting this law would help in any way to make our communities safer. Now, I also want to just talk for a second about this. This government has stood up in the House time and time and time again and said that the very best social safety policy, the very best social safety tool that a person can have in this country is a job. You won't hear any one of the members of the government contradict that today, because they themselves have said it, because they believe it. And you know what? In some ways, Mr. Chairman, it's actually true. A job is a pivotal part of Canadians' abilities to care for themselves and care for their families. We've heard absolutely inarguable testimony so far that getting a pardon is a critical part of having a person reestablish themselves in the employment world. We all know that when you go apply for a job, there's a section on an employment form that says, have you ever been convicted of a criminal offense for which a pardon has not been granted? The ability to check off that box or not check off that box is the difference between someone getting a job and not getting a job in many cases. And if we want offenders to come back out of prison and to reintegrate themselves into society and start repaying their debt to society and start acting like we expect our citizens to act and not be a burden on the taxpayer and not be a burden on the state, don't we want them to get a job? Now, of course, we want them to get a job if they've demonstrated that they deserve that kind of trust again. And the New Democrats are totally in favor of making a pardon process that is strict, that gives the pardon process the ability to deny that pardon, that makes that offender demonstrate that they have truly rehabilitated themselves through an extensive period of time of proving that, not through their words, but through a period of time that they have shown that they have not reoffended. And make that period of time a good, substantial one. Make it a long one in some cases. But getting a job is critical, and this 3 strikes and you're out proposal would harm that process. Now, I also want to talk about the lengthening the wait times. This bill proposes to double the ineligibility periods before applying for a pardon. It would go from 5 years to 10 years in some cases and 3 years to 5 years for summary convictions. Now, again, that is something that I think is a concept that's worthy of further discussion. It's worthy of learning more about. What kinds of offenses should go from 5 to 10 years? Now, as I've already said, New Democrats have already indicated our support for moving sex offenses against children from 5 to 10 years. And it may even be the case that there are some sex offenses against children for which a person should never get a pardon. New Democrats are prepared to look at that. But what this does with the broad brush is this government says all indictable offenses of every type should go from 5 to 10 years. Now, that is you take a criminal code that's that thick, and it has every single type of indictable offense, from impaired driving to shoplifting to forging a testamentary instrument to passing a bad check. There are all sorts of offenses that Canadians would recognize fall on a spectrum. They fall on a spectrum from the minimally serious to the moderately serious to the heinous. Now, there are some offenses that I think that we can all agree maybe qualify for the never getting a pardon process. but absolutely Canadians, the vast majority of Canadians would agree, because they're reasonable people with common sense, that there are some indictable offences that you shouldn't have to wait 10 years to get a pardon for. My colleague in the Liberal Party has brought up a very good example on several occasions of a young woman, perhaps a single mother, who gets in trouble and she's in her early 20s, who ends up writing some bad checks, or she ends up shoplifting, maybe because she's low income and needs to have clothes for her children, and she makes a mistake, and she has one indictable offense. And this government would say, oh, you have to wait 10 years after you serve your sentence, which in many cases would probably be 12, 13, 14 years. Plus, Mr. Chairman, we've also heard from businesses that exist to help people get pardons, that the pardon process itself usually takes a year or 2 years. So that one young woman who might have made a mistake at 20 years old might have to wait 15 years before she can get a pardon under this legislation? That is not considered legislation in my respectful submission. In terms of basic drafting, this bill has been rushed so quickly that we can determine that there's drafting flaws in this bill. We have the so-called problem that I think we finally teased out of the minister and out of the support staff, that I think they acknowledge that there's a drafting flaw in this bill, where the people who are convicted of sex offences against children and the way that works with respect to young offenders, you know, a 16-year-old and a 14-year-old or 17-year-old and a 14-year-old, the close in age provision is misdrafted in this bill. So we even have a flawed drafting issue here. Now, I want to talk just a bit also about what I will say with the greatest of respect is a little bit of conservative hypocrisy. We brought those three witnesses, those three offenders to this committee to show Canadians and show this committee who are the types of people that would be personally affected by this legislation. And again, I think it's fair to say that we heard compelling and touching stories of people with criminal pasts who have turned their lives around, who have completely turned their lives around. And Conservatives, to a person here, said to these people's faces, oh, we're really, really proud of what you've done. You know, we really admire the way you've turned your life around. And I think even one or two of them may have even said, I could be wrong, but they even suggested to these witnesses, we don't mean you. No, you're not the ones that we mean to prohibit from getting a pardon forever. We mean those other people. But of course, those were exactly the three people who would not get a pardon by this legislation. Worse, after sitting here in this committee, each one of the Conservatives talking to these ex-offenders and treating them with respect and praising them, they stood up in the House the next day, the very next day, and they made outrageous statements disparaging those very courageous individuals who came to tell their stories. I'll quote, I won't mention the name, but I'll quote one of the members in the House. Quote, yesterday, he said, this is the day after these former offenders came and bravely testified on television about their criminal past and how it was turned around. Took more courage than I have seen many Canadians demonstrate in a long time. And they said, yesterday, this is what the Conservatives said. Yesterday, the Public Safety Committee heard pleas from the convicted criminals to keep Canada's pardon system as is. Like so many times before, the Liberal public safety critic showed that he put the rights of criminals before the rights of victims, end quote. Which, of course, is not true. But no, this is part of the rhetorical nonsense that you hear from the government that accuses anybody who might want to bring some study and some subtlety and some intelligence and some facts to the debate of crime. They accuse us of putting criminals before victims. What kind of nonsense? What nonsense? But they did it. And worse, the two-facedness of telling these people to their face how much they admired them and the next day going into the House of Commons where they have parliamentary immunity and portraying them to the Canadian public like we had a bunch of common criminals who wanted the pardon system liberalized. was about the biggest piece of hypocrisy that I've seen in a long time. Now, I want to talk again about evidence. So far, the Conservatives have not tabled one piece of evidence, one statistic, one study, one piece of data that shows why these changes are needed before this committee or how they would improve community safety. Now, I want to talk again about the Conservative approach to make legislative changes based on politics and based on fear and not based in the face of evidence. We have a couple of examples at this committee. Bill C-5, the International Transfer of Offenders. They put this bill before this committee. It was unanimously panned by the witnesses. Conservatives couldn't find one witness, not one witness who supported the bill. They brought C-17, we heard this expert panel yesterday, expressed grave concerns about the impact on free speech and basic. Yes.
I'm trying to give you as much, obviously we're in a filibuster here as you're trying to prevent us from going to clause by clause. I am trying to give you as much leeway as possible. You have been speaking about pardons. You've done a remarkable evaluation and review of all witnesses that have appeared before our committee up to this point. But if you're going to start going back to the other pieces of legislation that you've prevented us from moving ahead on as well, then you know, I'm going to call relevance on it. So and then I'll just move to Mr. Holland. But if you want to keep on, the pardon system, I'll give you as much leeway as possible. But when you start going on transfer of offenders and when you start moving on some of those other pieces, then I'll try to rein you back in a
Certainly,
little bit.
Mr. Chairman. I'll be happy to get back to pardons. I have a lot more to say about it, and it was simply to point out the flawed approach of the government. But I will say this. I object very strongly, Mr. Chairman, to your characterization of what I'm saying as a filibuster or to impute a motive to what I'm saying. You have never done that, Mr. Chairman, to any one of the members of your side when they have obviously filibustered, and they do so repeatedly.
You have a half-hour speech going. That's fine.
Mr. Chairman, I'm speaking. I have the right to speak. I have the floor. Please don't interrupt me.
I'll interrupt you when I feel like I'm going to interrupt you.
Will.
I'm just asking you to keep this relevant to the discussion of moving this bill to clause by clause. A lot of what you've referred to is technical amendments, technical changes. We're prepared. You know, there's been amendments made and brought forward. Keep it to the bill.
Mr. Chairman, I will. I have spoken on nothing but relevant information to the pardon bill up to now. What I'm talking, I understand your point and I've accepted that. What I'm talking about is your editorializing to characterize unfairly what I'm speaking about. I'm speaking about Bill C-23B and the motion here. And if I have a lot to say, that does not constitute any attempt to block anything. There just happens to be a lot of flaws to this government's. It takes a long time to point it out. Now, I want to talk about serious gaps in what the committee has heard. One thing that we have to remember is that the current law right now says that a person convicted of a sex offense will always have that record searchable. Canadians need to know that whenever anybody has been convicted of a sex offense, that always is subject to an organization, particularly ones that work with children, to having the police search that and give them the information. Sex offenses are never erased. And again, there's a database that exists that can be searched, and it should be searched. Because anybody convicted of a sex offense we should be very vigilant to make sure those people never work with children, and that they never, ever are put in a position where they can harm again. Now, I want to also mention that we've heard evidence that I think it was 96%, if I'm not mistaken. I see Mary Campbell here. I hope she can correct me on this if I'm wrong, because it was her testimony. Of those granted a pardon over the last 40 years, do not have those pardons revoked. I think it was 96%. Now, that means that those people never reoffend. So that should tell us that right now the pardon system in practice is working relatively well. And we also need to remember that people who are granted pardons automatically have those pardons revoked if they reoffend. So there are some built-in safeguards here. But this bill would seek to create broad categories of offences for which individuals may never apply for a pardon. So what I'd like to say, Mr. Chairman, and move to here, is before making these drastic changes, I want to hear from more witnesses. I want to hear from more former offenders. I want to hear from more victims. I want to hear from more professionals who work in the field of corrections. I want to hear from more people who work in our prisons. I want to hear from parole officers. We have not heard from one parole officer. The very people who work with former offenders, that know them best, we've not heard from one of them. I already have lined up, just myself, half a dozen witnesses that I would like to hear from, including some from the government's own ministry. I want to hear from researchers who can come before this committee and give us some data about how the pardon system works and what kind of changes we can actually make that can improve the pardon system so that we make sure we're giving pardons to people who deserve them and we're not giving pardons to those that don't. Now, sound policy and legislation is based on facts, not myths. It is based on knowledge, not ignorance. It is based on improving public safety, not rushing to make knee-jerk laws that end up making us less safe. The government side had all fall session to push Bill C-23B. They came with a motion last Friday to go in the last week before the Christmas break, just on Friday, to come the very last week. We're probably going to end tomorrow or maybe Thursday. They waited until this week to bring a motion to go to clause by clause on C-23B when they know that we have more study and more evidence to hear. Why did they do that? Because they're playing politics. I have no doubt that the Conservatives are going to run out of this room and they're going to spin this to the Canadian public saying the opposition is holding up pardon legislation. They're not going to tell Canadians any one of the 10 facts I just mentioned, that they had all fall to deal with it and threw in a motion at the last minute to try to make it look like they were dealing with something that they haven't dealt with. They're not going to tell Canadians that we haven't heard from a single parole officer or a single person who runs a halfway house that deals with former offenders. They're not going to tell Canadians that we heard from 3 people who have experience with rehabilitating their lives. So I ask, Mr. Chairman, what are the Conservatives afraid of? Are they afraid that the Canadians will actually understand that their bills are put forward and their actions are put forward for political purposes and not for sound legislative reasons? Do they want Canadians to know that their bills are hastily written, ill-conceived, and designed with politics in mind? Well, I think Canadians want us to make sound policy, Mr. Chairman, and I'm going to oppose this motion for one final reason, because I want sound pardon policy in this country. I want to make sure that we give pardons to those that deserve them and that we don't to those that don't. And that requires us to take a bit of time. There is no urgency to this. We have waited decades for pardon reform, and again, Stockwell Day reviewed this just 3 years ago and thought there were no changes that were necessary. This committee made changes back in June. This Parliament made changes back in June that are substantial and they're profound and they're needed. We can afford to go and take our time a little bit on this, and that's what I would suggest. So I'm going to vote against this motion, Mr. Chairman.
Thank you, Mr. Davies. We'll now move to Mr. Holland.
Well, thank you, Mr. Chairman. I will start off with something that that I hope you don't deem to be irrelevant, but I think it's because I think it's important to mention. This bill was introduced about 6 months ago. Now, of course, we had the summer where we couldn't do anything. Obviously, we weren't sitting. We've had 3 meetings on this. We've been going through hearing from a number of witnesses. What I find curious, passing strange, is I was sitting in the House yesterday speaking. In fact, unfortunately, Mr. Chairman, I know much to your disappointment, I had to miss part of the meeting yesterday in order to speak on C-43. Was the fact that, that when speaking on C-43, we're getting nowhere on that bill. That's a bill that was introduced maybe 8 months ago. This is on unionization of the RCMP, and we can't beg or plead the government to move it forward. Take lawful access. I was just speaking to my assistant about the lawful access bill, thinking that I had spoken on it twice, and that it was, when was it coming back here? No, it's introduced yet again. It's been sitting there for 5 years. 5 years. And the government is bringing out the whip and say, pass this tomorrow because, you know, you bad opposition, you're holding things up. If you want examples of holding things up, how about your representation by population bill? Where the heck is that thing? Introduced in April, been sitting around languishing, collecting dust. So here we are. We've had witnesses in the time that we've had. Sorry, Mr. Chair. In the time that we've had this before us, we've had witnesses. We've been diligently trying to work on this bill, and then all of a sudden we get this motion. And what is outrageous about it is that in the House, you get statements by members. I'm not going to get. I think Mr. Davies spoke very eloquently about how ridiculous it is, but I really think it descends into farce. You know, I mean, when I stand up, when I walk into the House, and every day there's an SO31 about me, or there's a question in the House of Commons about me. That's very nice to see that you care so much. But the reality is, do you think anybody believes this nonsense? When you stand up and
Mr. Lobb, on a point of order.
Appreciate Mr. Holland's comments. Just relevance to the to what we're discussing today.
Well, Mr. Holland did say that he was going to take a little bit of liberty in his introduction, moving it towards Bill C-23, and I think he's moving that direction. But I will encourage Mr. Holland to, again, as I did to Mr. Davies, to keep it relevant to the discussion.
Well, I think this is really germane to the discussion. Mr. Lobb, to you directly, this is about this bill. There are members standing up, conservative members standing in the House, saying that I side with pedophiles, that I side with sex offenders. I mean, how dishonest. When members themselves, through the course of committees and talking to witnesses, express sympathy for their situation. When we hear from a young Aboriginal man who went through the horror of the residential school system, and who had to deal with the pain of being a victim and going through that system, and of course he unfortunately acted out in ways that, you know, he probably himself wished he hadn't. Committee members express sympathy for him, express happiness that and congratulations that he's moved beyond that, and he's now moved into a life where he's being successful, and he's a long time of being clear from any criminal wrongdoing. Committee members express that sympathy, and then the next day talk about them as hardened criminals that we should have no sympathy for. It's pretty rich, you know. And my problem is that when I've expressed concerns with this bill, it's not been with respect to serious sex offenders. It's been with respect to circumstances, as I've outlined earlier, where you could have somebody who is a young mother who is finding it very difficult to make ends meet, who makes some bad decisions, writes some fraudulent checks. And that series of decisions could put her in a situation where she's never eligible in her entire life for a pardon. And when I ask questions of the minister himself acknowledges that there are weaknesses in the bill and that it needs to be amended. Right? And for posing those questions, even when the minister agrees with me that the bill needs to be changed, the next day in the House of Commons and for many days thereafter, I'm talked about as being soft on crime. Well, I mean, I understand the objective, which is purely political, but I think it's a darn shame, because at the end of the day, there's actual lives tied up in these games. There's people who are actually going to be impacted by the politics that are being played here. So when we sit at this committee and we have an opportunity to debate this bill, when the government attacks anyone who asks thoughtful questions, when the government goes after and maligns and smears somebody who simply wants to ensure we pass good legislation, shame on you. You do an enormous disservice to this place. You do an enormous disservice to good legislation and to good debate. And I think, you know, members really need to reflect upon that, upon the reasons why they're sent here to a committee like this. And when you have witnesses like we had here, people who are often caught in cycles of victimization, victims themselves who then play out a cycle of victimization and criminality, who've broken it, who clearly have gotten better, who put that in the past. The gentleman who I think we were all taken by, who in a difficult time in his life was selling steroids, acknowledged the mistake, acknowledged it was something he shouldn't have been doing. Folks, that gentleman that you were expressing sympathy to, that you were saying you were commending for the improvements that he'd made in his life, would, under this bill, potentially never in his life be able to get a pardon. I think the other thing that bothers me, Mr. Chairman, is that when we take a look at the amendments that have been given to the committee, we really can't. You know, I was here at about 5:30 yesterday when we were in receipt of the amendments. We had an emergency debate last night on Haiti. I didn't leave the House. I don't know about some of the members. I didn't leave the House until about 11 p.m. at night. I was about 19 hours on the road this morning. 19 hours? Well, it's to make a point. It's pretty horrific roads this morning. But my point, Mr. Chairman, is when are we supposed to look at these things? I mean, you know, I suppose if I forewent sleep last night, I could have had the opportunity to look at the government's amendments that they so kindly gave to us late last night. But, and I can see Mr. McColman feels very badly for me. But my point is that if we're here and we're going to be debating this matter, how can we seriously debate amendments that we haven't even looked at? And the second point that I would make, and I would ask directly to the government, the minister acknowledged, and Mr. Chairman, I saw in your own comments, that there was room for this bill to be amended, and there were areas where it needed to be improved. Yet I don't see any of those amendments before us. And I certainly, you know, we got, I think, a couple of days' notice that we were going to be dealing with this. I suppose the government's intention is that we should fix their bill in that period of time, that I should have been sitting by candle through the night writing legislative amendments. I mean, this is what is ridiculous about this notion that we have to move on this now when the government itself has acknowledged this bill needs amendments, it needs to be changed. And I would ask the government, where are those amendments? Are they willing to bring them forward? Are they willing to aid us in drafting them? I can give them very specific areas where this legislation needs to be amended and improved. So I have no problem at the appropriate time moving to clause by clause and moving forward with the bill once those amendments are ready, once we've had an opportunity to look at how many pages here? 15 or 16 pages of amendments that we got late last night. Once the government has had an opportunity to draft and deal with some of these items, and also that we've had an opportunity to finish hearing from witnesses. There are several witnesses that are still on the table that different members have wanted to hear from that we have not heard from, Mr. Chairman. I'm concerned, as an example, that we haven't heard from any groups representing women offenders. And obviously, for female offenders, this is going to have serious ramifications. And yet, at this point, we still have not had an opportunity to hear from any of them. So, at this point, Mr. Chair, if the government could comment on some of those items, I'd be so that we could see whether or not we're going to go forward. I'll turn it over with those, and I can repeat them if Mr. McKenzie isn't clear. But when can we get those kinds of amendments? What about hearing some additional witnesses? What about giving us a little bit of time to look at the 15 or 16 pages of amendments that you've given to us? If you're serious about this bill and you're serious about really passing good legislation and not playing games, can you give us those kinds of answers?
Thank you, Mr. Holland. I'll go to Madam Morani, and then I don't know if anyone on the government side, but Madam Morani.
Je pensais que c'était Monsieur Mackenzie.
No,
Thought it was Mr. McKenzie. He won't be speaking. Okay. Thank you, Mr. Chairman, for allowing me to speak to this bill. And I have a number of points to raise. First of all, I would admit that I'm somewhat disappointed. It's disappointing because, on the one hand, if I take an objective view of this, it seems to me that this government doesn't change its technique. It just puts on a show. And once again, today, we're witnessing a show. The government, unfortunately, doesn't understand that public safety is important. It's basic. It's something that you don't fool around with. You don't take someone's life lightly. And I find it extremely insulting that we are pitched, as you might say in good Quebec jargon, we're being pitched this. Here are amendments. We want to move to a clause-by-clause study. I find this unfortunate because I have witnesses that I haven't heard yet, witnesses that I would like to hear from. For example, the Quebec Association that's called Plaidoyer Victime, pleading for victims, and this group has been dealing with victims on a daily basis for years, and unfortunately, because of time constraints, they weren't able to appear, but they would like to appear before this committee, and I'd like to hear what they have to say about this bill. I'd like to hear what the victims have to say. We heard from the minister, who seemed to be saying, with respect to the three strikes law, that, well, that seemed kind of interesting, even though there were no figures to back up his claim. He felt that it was a logical process. And what we want to hear from are people, or who we want to hear from, are people who have these figures, these statistics, people who are directly targeted, people who have dealt with the legal system. And I'd also like to hear from victims, because the government says that it is the champion of the victims, but we haven't heard anything from them yet. We are waiting to see whether they will support C-343 in third reading, and that's a little aside, Mr. Speaker, but it's a bill that deals with victims, and we're waiting to see if the government will support it. But we haven't yet heard from any victims. Yes, we did have one person who spoke about her experience, and it was extremely interesting to hear what she had to say, but I'd also like to hear from groups that represent victims. And these groups, we hope, might be able to tell us what the people with whom they work really think about all of this. What I mean are the people who represent these victims. It's unfortunate that today we're debating how this bill will be moving forward, even though all of us around this table, I believe this truly, everyone around this table is working in good faith, and we all want to put forward bills and laws that protect the safety of the public. At least that's our position at the Bloc Québécois, and I don't understand the urgency here. I really don't understand why we would want to rush this. And let's talk about realities here. If we were to adopt this motion today, I'd like to know when we would have time to move to clause by clause. It would be next year, when the House resumes sitting. So even if we were to all agree on this motion, it wouldn't go any further. We would have to look at this next year. So it really is a show. And I'm sure you understand what I mean. And that's disappointing in itself. Now, I gave this a great deal of thought, and I wondered what we could do to improve this bill. Even though we haven't heard from everyone, there might still be some good ideas that various groups might provide. And in order for us to properly understand what I am saying, I'm going to move point by point here. At this time, when we talk about a pardon, we talk about suspending a criminal record. Now, when you suspend a criminal record, what does that mean in concrete terms? At this point in time, depending on what your offense was, when you have served your sentence in full, whether it be incarceration, probation, fine, whatever, at that point you can apply, and it isn't automatic. You have to apply for a pardon, Mr. Chairman. You don't just get it automatically. They don't say, well, he's eligible, he gets a pardon. No, you have to apply for it. And it takes a while to apply. It can take up to a year because there are various stages. You have to fill out a form and look at the criminal record, make the application. There's a whole list of things that have to be done. You have to go to the court to get the list of offenses. You have to go to the police station and have your fingerprints taken. So it does take some time. It can take up to a year. And then, after that, the file has to be processed. And it depends. You might be told, well, this will be done in 6 months. But at that point, let's say that your application is accepted. Then your record is suspended. But if tomorrow morning you go into a corner store and steal a bag of chips, the fact that the police stop you because you've stolen a bag of chips, and I don't know if you have a criminal record here, but anyone who has a criminal record will have the criminal record reinstated. Now, what does that mean? It means that it's automatic. You don't have to apply to have it reinstated. As soon as you're arrested again, it's reinstated. So it hasn't really disappeared. That's one thing. Now, even if you do have a pardon, it's called a pardon at this time, if you are granted a suspension of your criminal record in the United States, it is not eradicated or removed. And we have met people who have had their records suspended, who had committed offenses in the 70s or 80s. And I don't remember which ones. For example, people who were in demonstrations and they were arrested. These people are then arrested if they go to the United States because their criminal record still applies there. So they have to go through an entire system where they tell the United States, yes, there is a criminal record, but these various steps have been taken. So there's a whole process for anyone who goes to the States. Now, let's look at figures. There are a few figures that the minister didn't have, but we happen to have some of these. And this might allow us to understand whether or not the system is working properly. And I'd like to point something out, Mr. Chairman. This bill is a leftover bill, something that was left over from a bigger bill, C-23. And it was divided into two parts. This is 23B. And I don't know if you remember this, Mr. Chairman, because this was something that was pitched at us as well. It was thrown at us just before we left in June. This seems to be a specialty. There was a show that had to be put on that day. It was the Homolka show. I think you'll understand what I mean. So you needed actors, you needed the media. This was all put together. It was the Homolka show. And the result of that is that we took a look at C-23 and we said, well, it makes no sense. Let's have a look and see if we can find something good in this. Let's pull out the good parts, and this is what we all did. In good faith, we took a look at it, and we said, well, and I'm just showing you this here. At this time, what was added to what already existed is that if you are accused of a serious offense against a person according to 672 of the code, then you're going to have to wait 10 years, my friend. 10 years. 10 years applies when? 10 years after you have served your entire sentence, paid all of your fines, finished all of your probation. So if you have a 5-year jail sentence or prison sentence, then you get 3 years of probation and you pay your fine, maybe a 4-figure fine. You have to wait 8 years, Mr. Chairman. And after those 8 years, after everything has been done, this is what you have to do. Now, be careful. This won't be automatic. You have to apply. And when you apply, you have to fill out your form. And you have to have your fingerprints taken. You have to go and see the police. You have to go to the courts. So if you are discouraged by the entire process, it will take you a year. But then, Mr. Chairman, after 8 years, 5 years in prison, 3 years of probation, you have to wait 10 years. So when the dust settles, it will be 18 years. But don't forget that it takes another year for the processing. So let's say 18 plus another 2 years, 20 years, Mr. Chairman. So you committed a serious offense, and it will take you 20 years before you will have a piece of paper that will allow you to work. And this is the reality. Why do people want us to suspend their criminal record? Is it so they can have a little piece of paper to put in their file? No. Why do you want to have your criminal record suspended? The first reason is so that you can get a job. That's the main reason. And employment allows people to feed their family. It also allows you to avoid falling back into a life of crime. Any sociologist, any social worker, any police officer, any person who has met an offender understands that that person has to work. And I'm sure that my friends across the table here understand this as well. Why does a person have to work? To pay his taxes. That's good for us. It allows you to put more money into the penitentiaries and the prisons. So if they could at least pay taxes and not draw EI or be unemployed, it would allow you to have enough money to pay the billions of dollars that you're going to invest in prisons, Mr. Chairman. So when you work, Mr. Chairman, it allows you not only to stop, it allows you to rather make a step towards rehabilitation. It also allows you to take care of your family. And that is how you protect society, Mr. Chairman. It's not by telling people, well, we're not going to suspend your criminal record. You're going to remain stuck for the rest of your life. You won't be able to work. And we're not saying that they're going to go and work for the government. If you want to be a trucker, just a trucker, you can't have any criminal record. And if you are a trucker, if you are a truck driver, and your route takes you from Montreal to New York City or somewhere in the States, well, it is even worse. You can't have a criminal record if you want to drive a truck. So can you understand how important this issue is? It's very basic. Now, I would prefer to see these people working. I would prefer to have them work rather than be on EI or on social assistance, and they would not even draw on employment insurance, because if they've never had a job, they won't be eligible. So what do? If they can't get a job, then they want to take vengeance on society. They feel that they're being discriminated against. They're rejected. This is also very basic, and we've seen examples here of people who have rehabilitated themselves, who have families, and if some of these people, if you did not know they had had a criminal record, you would never have suspected it, because they're model citizens. But they aren't the only ones, Mr. Chairman. Look at these figures. As I said, I'm going to give you some figures. 97% of those who have had their records suspended have not seen these revoked. 97%. So 3% of them had their records reinstated, and it wasn't necessarily because they had reoffended. This is something that we could look into. I find it interesting, so maybe we will. But if we look at the figures, what do we see? According to the 2009-2010 data, we can see that there would be 3,800,000 Canadians who have a criminal record. 3,800,000, more or less. And of these 3,800,000 Canadians, less than 11%, rather, of those who were charged or convicted have had their records suspended. The parole board for 2009-2010 received 32,105 applications for pardon, and it agreed to consider, this doesn't mean these people were given pardons, but out of the 32,105, they agreed to consider 24,844 applications. So 77% of the applications were accepted, and during the same year it reviewed 24,559 applications. Now, how many were granted? 16,247. So 16,247 pardons were granted. 7,887 people did receive their pardons. So this represents 97% of those people, and it's quite something, really. What it tells me is that when I look at these figures, even if you apply for a pardon at this point in time, it doesn't mean that the parole board will decide to review your application. It can accept your application, but it can also be rejected without even being considered. This is what I understand, because out of the 32,105 application, it agreed to consider 24,844 and granted 16,247 pardons, or rather 7,887 pardons were actually granted. If we look at the figures, well, this isn't it doesn't mean that there's any rush, and I'm not sure how the interpreters will interpret the term that I use. But in any case, we have to decide whether or not the suspension of a criminal record is important. I would say that it's fundamental, it's basic, but we can't put everyone in the same bag, if you will. This is something that we all agree on, I believe. Someone who is a sexual offender should not have a pardon, should not be granted a pardon. But some lady or some fellow who steals something at the age of 18 as an adolescent, well, we can all agree that we're not all saints, and from time to time there can be a lapse, and we can wisen up eventually, and therefore we should have an opportunity to really start our life. And the reason why these people want the record suspended is because they want to make a fresh start in life. Now, if we look at 23A, we see that Appendix 1 is included, and I'm talking about 123A. So if a person is condemned to 2 years or more, or convicted of an offense in Appendix 1. So if you are convicted of an offense in Appendix 1, it will take 10 years for you to have your record suspended. That is 10 years after having served the sentence, etc., etc. So it isn't really 10 years. It's more like 20 years, according to our calculations. Now, if I look at Appendix 1, for the layman, you will see that there's an entire list: sexual offense with a child under the age of 16, exploitation of a person age 16, bestiality in the presence of a child less than 16 years of age, inciting a child to commit bestiality. This is disgusting. We all agree on this. Child pornography, mother or father acting as a pimp, etc., etc. So between you and me, Madam, can you talk about this in terms of, can you give this term to a criminal leaving off the avails of prostitution for someone under the age of 18? And I could continue at length. So this can be found in 23A, and I'm wondering why this is so urgent, because we already adopted 23A. This was done by the fast-track method, and we all agreed to do it. So what's the issue here? Why do we have to have this thrown at us today? A lovely morning like this. Can you explain? There is no explanation because it's a show, and this was the aim of today's performance. And I agree on this. I believe in this, and nothing will change my mind. Now, if we look at 23B, when we take a look at 23B, what is wrong with it? What's the problem? Is it the fact that we will abolish the term pardon and replace it by suspension of criminal record? Well, Mr. Chairman, don't you think that all of the terminological studies having taken place, now that you want to substitute suspension of a criminal record by for a pardon, well, you really have to have a lot of time on your hands in order to be able to come up with that. Why do they want to remove the word pardon and replace it by suspension of criminal record? And once again, Mr. Chairman, something else that's basic. They want to abolish the term rehabilitation. They don't like that word, rehabilitation. Boy, oh boy, I can tell you that this is a terrible word. When you say rehabilitate, well, you can't even finish saying it. You're cut off at the pass. We see this in all of the bills, and there's something they don't understand, and this is basic. When you study a criminal mind, or when you study criminology, if you will, public safety is based on rehabilitation. In Canada, we have a system, and it's envied the world over. Why is that? That's because we've decided that in order to protect society, you had to ensure that people would be rehabilitated. And there are other concepts that I'm wondering about with this new government, because systematically in all bills that they put before us, they want to put an end to rehabilitation. So what do? They replace the word rehabilitation by public safety. Public safety, protection of the public. But what they don't understand is that rehabilitation means protection of the public. But they think that incarceration is required to protect the public. So they didn't understand, and it didn't work. It didn't work in the United States. It didn't work in other countries that adopted this method. We have a good system. Yes, there's room for improvement from time to time, but you don't throw out the baby with the bathwater. You don't change an entire philosophy, something that does work, and rehabilitation is basic. But I'm ready to give a training course to all of the Conservative members to explain what rehabilitation means and how it can allow us to ensure that the public will be protected. Now, when we look at this bill, but just hang on a sec, before I discuss C23B, there's something else that I want to say, and this is something that you can take a look at. It's beautiful. In fact, once upon a time, there was no criminal record. We didn't have the technology. It wasn't easy to have the name, the address, the fingerprints. It just didn't exist. Mr. Chairman, did you know what they used to do in the Middle Ages to identify people who had stolen or killed someone, who had done something wrong? How were these people identified? Today they're identified by their criminal record, but in those days they were branded. They were branded. That's how you identified a thief. T for thief, M for murderer, A, and what was the A for? Adultery, Mr. Chairman. Can you believe it? Women who were adulterers, in some countries they are stoned, but in the Middle Ages, in the Western world, and not in exotic faraway lands, well, there was the Scarlet Letter. And society has evolved. We have evolved. We no longer brand people. And how was it done? Well, torture was commonplace. So they were tortured until they admitted their guilt, even if they weren't guilty. Because, you know, if you're being tortured, you will admit anything, Mr. Chairman. You will even make things up so that they will stop torturing you. And so I've always said that information obtained through torture, as is being done, is not a good idea. It's not reliable. We have evolved. We are a modern, contemporary society. We no longer live in the Middle Ages. However, and perhaps you can't picture what this means, but think of cattle. Think of cows and bulls when you want to brand them. I'm sure you'll understand that. He understands what I'm talking about. So you take a cow or a bull and you want to indicate that it belongs to a particular farmer. You take this piece of metal with a symbol or a number, you put it in the flames, and when it is really hot, and I'm explaining this, when it's really hot, you take it and you brand the person's back. It didn't smell very good, and it didn't feel very good either. Now, I wasn't there to witness this, but I can imagine how it might have been. Society has evolved, and we invented something called the criminal record, and all of the information is contained in the criminal record. But what is interesting is the fact that only the police see this. The public can't see this. It's not like in the Middle Ages when someone was branded with a V or an M or a T. In the Middle Ages, these people were outcasts. They didn't work. And the same thing applies today. When you know that someone has a criminal record, no employer wants to hire that person. And we'll agree on something, Mr. Chairman. If that person is a pedophile, well, I can't speak for my colleagues, but I'm sure that my black colleagues feel the same way. If that person is a pedophile, well, of course, we agree that that person should have a record and should not have the record suspended. We all agree on that fact. I wouldn't want my child, my son, to be in a daycare or playing hockey and being approached by a fellow. You will say that women are also pedophiles, but unfortunately, most of them are men, and figures do not lie. So I certainly wouldn't want to experience that, and I wouldn't want my son to experience that. So we all agree on that fact. But in C23B, as it is currently drafted, do we find that provision? Not at all. Not at all. Because contrary to what can be seen here, that is, make ineligible the suspension of a record of anyone convicted of sexual offense against a minor. Well, everyone will say that's fine, but if you take a closer look at the bill, you will see that there's a whole list of offenses other than that particular offense. Now, we will be introducing amendments. The Bloc will be introducing amendments, and one of the amendments will be the following. A suspension of a record will not be granted to anyone who is convicted of a sexual offense against a minor. That we will agree to, but we have to be careful, Mr. Chairman. We have to, at all costs, be able to continue to debate this before jumping into the clause-by-clause process. Why is that? Because we still have witnesses to hear. We might be able to add some points, something that might help to make this bill even more effective. Because our aim, everyone's aim here, is what? It's to protect our children. However, we do want to protect our children, but not in any way. The children of Quebec, the children of Canada are our children. When I turn on my TV and I see that a child has been sexually abused, it's terrible. We're not made of wood. We are affected by this, and we want to amend this bill. We want to improve this bill, and I think we are all acting in good faith here, but not in just any way. We don't want to penalize people who can be rehabilitated, and we've seen examples here. Thank you very much. If I may, Mr. Chairman, I'm just going to take a little sip of water. I'd like to take a sip of water, if I may. Thank you.
It's certainly not because of your dry
Pardon?
humor or your dry content. It's because, yeah, continue.
Je reconnais là votre humour, monsieur.
Oh, I see that you have a sense of humor, Mr. Chairman.
D'ailleurs, je voudrais profiter.
I'd like to take this opportunity to wish everyone who is watching this morning a very Merry Christmas and Happy 2011. I wish you health and prosperity. We haven't yet done this, but I'd like to do this on my own behalf, on behalf of the Bloc, on behalf of all of my colleagues sitting around the table here, because I'm sure that my time will run out fairly soon. However, I haven't finished, Mr. Chairman.
Appreciate the fact that you are wishing the millions of Canadians today that are, I'm sure, glued to their television watching this a Merry Christmas. However, I would encourage you, because I have encouraged Mr. Davies and I have encouraged Mr. Holland, I would just encourage you to, not that I want to be a Scrooge or a Grinch that stole Christmas, but rather I would just trust that you would move it back to C23B.
Ah oui, bien sûr, bien sûr. Puis,
Yes, of course. No problem. And since we're talking about a bill that is aimed at protecting through one provision, that is, it deals with the ineligibility of the suspension of the criminal record of those who have been found guilty or convicted of a sexual assault against a child. Since we're dealing with this provision that we do support, I'd like to wish all of the children in Canada and Quebec a very Merry Christmas. I wish their parents a Merry Christmas, but of course Christmas is for children. So these wishes are for children, and I'm sure that I will be able to wish a Merry Christmas to children. You're not going to prevent me from doing that, Mr. Chairman. Is it okay if I say Merry Christmas to the children?
Name, you know, if you're going to name each one of them.
Mais
Are you
si je les
planning on naming?
connaissais, je peux vous dire que je
All
le
right,
ferais, mais
continue.
bon, non.
If I knew them, yes, I certainly would. No, Mr. Chairman. And I will wish you Merry Christmas later. I'm sorry.
Alors l'autre point, excusez-moi. Excusez-moi, Monsieur le Président. Donc, après, c'est merveilleux.
I apologize, Mr. Chairman. So after these wonderful wishes, I will continue. With respect to C23B, the one sticking point here, and I'm sure my colleague, Mr. Davies, has, as well as my colleague, Mr. Holland, would agree, but Mr. Davies in particular, I believe, explained this. And how do I explain it? The fact that the criminal record suspension doesn't apply after 3 strikes with sentences of more than 1 year. 1 year incarceration, Mr. Chairman. 1 year in jail. Well, where's my criminal code? I could give you a list. I'm sorry, I don't have it with me. That's a shame. Oh, thank you so much. It would appear that it's in English only, but I will translate it. So, in any case, 1 year sentences. There are dozens. Theft, shoplifting, but it depends on the amount that was stolen. If you stole something worth $5,000 or more once, then there might be a fine. However, it's a criminal offense, so you're charged. Now, if you stole less than $5,000 worth of merchandise, there will be a fine, but it will be a summary conviction. So let's say that you stole something worth more than $5,000 and you had a fight when you left a bar. Now, it's not the same offense, Mr. Chairman. These 2 occurrences might have been a few days apart, but this is just a simple example. So the person goes into a store, steals merchandise worth more than $5,000, gets caught, has a fine, has a record. And then 2-3 days later, that person goes out with his girlfriend. Someone tries to pick up his girlfriend. He's not happy. He starts a fight. And we see this every day. It's a very typical occurrence. Unfortunately, the result is not always a good one. So what happens? You get a second charge. The sentence might be 2 or 3, 4 or 5 months, let's say, if the judge feels that there was a lot of violence, and it depends how you evaluate the level of violence, but it could result in a 1-year term. So you spend a year in a provincial prison. Well, there are so many people in these jails. That person might serve 1/3 of his sentence. So let's say he's incarcerated for a few months. He goes back and sees his girlfriend. She dumps him. Things aren't going well at work. And so this fellow then commits an armed robbery. So he goes back to jail, then he serves his sentence, but he's had his 3 strikes. However, in jail, he met with a clergyman, someone who put him back on the right path. He decides he's going to go see a psychologist. He's going to take anger management courses. He realizes that he has all of this anger. He says, I have this anger in me, and I'm not talking about myself, but by this guy. Now, we talked about a show, so let's continue this show, this conservative show. In any case, so I say to myself, well, I'm going to work on my anger so that and in order to work on my anger, I take anger management courses, and I might meet a psychologist, or I don't know. There's a long waiting list, so I might have to see a psychologist. But in any case, he meets someone who sets him on the right path. He meets a wonderful woman who says, forget your girlfriend, quit taking coke, let's work on the abuse that you've experienced. You don't become a criminal overnight, you know, Mr. Chairman. There's always a background, a terrible background. I worked in the prisons for a long time, and I've never seen a prisoner who had had a wonderful life. So you say to this guy, well, you're working now, you have a family, things are going well, and this fellow wants to get a job and is told, well, you have a record, we can't hire you. He doesn't want to fall back into the life of crime. He works at dirty jobs in order to feed his family. He goes back to school, he gets a diploma, he's eligible, he could get a good job, except that once upon a time there was a conservative government that decided that after 3 strikes, 3 offenses, well, tough luck, Chuck, you won't be able to have your record suspended, even though he's gone to school. And I can see this very clearly, and this scene plays out every day. The time comes when he can apply to have his record suspended. He's delighted. He says, I went to school, I took charge, I have a wife, kids, everything is fine. Unfortunately, I have poverty wages because I can't get a decent job, but now I'm going to ask to have my record suspended, and I'll be able to work in my field because that's what I studied. But then he takes the little piece of paper that he's been given, he fills out the form, he does everything, gets his fingerprints taken, and then he's told, well, gee whiz, no, you've had 3 offenses. Yes, that's true. Well, too bad. You can't have your record suspended. And, well, gee, I've been clean for years. I haven't committed a single crime in years. I'm a model citizen. This fellow's a taxpayer, so he allows the conservative government to put money aside for the prison system. He's making his way in the world, and he's told, well, no, you can't have your criminal record suspended because you committed 3 offenses. But, Mr. Chairman, not serious offenses, offenses for which he served less than a year. Well, I'm sorry, but, or rather, that he served more than a year and a bit.
Annie, that according to this bill, with only 3 offenses, they still would qualify, but they wouldn't with 4.
Maintenant, Monsieur le Président, je vous relis ce qui est marqué ici.
Well, I'll read what it says here. Ineligible. And what does ineligible mean? And I can define it for you. Ineligible, something that is ineligible. What does this mean? And what do you think it means? Ineligible means not eligible. Not accepted. Something that's not admitted. Let's say that you want to apply to have your record suspended. You'll be told you're ineligible. And I could give you a dictionary definition, but I don't have a dictionary with me. I should have brought it with me. It's an indispensable tool, but I don't have it today. In any case, anyone who's ineligible is someone who would be convicted of more than 3 offenses with sentences of more than 1 year. So if you have committed that type of offense, and we have to understand something here, you will have cases where an individual might have committed a crime more than one crime in less than a month, because the person's very survival might be at stake, or there might be a great deal of anger. So you can commit more than one offense in a month, and sometimes you have highs and lows. In any case, in all of this, what we must understand, Mr. Chairman, is that this particular point in the bill, this particular provision, is unacceptable because it challenges everything that we've done for years in Quebec. Rehabilitation is no longer accepted, and many people have come to tell us here that in their own life they had committed offenses and they'd been given a pardon. One person said that if this bill were to pass, he would not be eligible for a pardon because he's in the process of obtaining a pardon. And what they're saying is it's no use being rehabilitated, because as soon as you've committed 3 offenses, you won't be able to have your criminal record suspended. So this is the message that we're giving these people. Well, it's a free-for-all, no point in rehabilitation. It will be useless. Whatever you do, it doesn't matter. You can fight tooth and nail. And this is important. This is important, Mr. Chairman. What I've already said was important as well, of course, but this is the link between what was done in the Middle Ages and what we're doing with this bill. We'll be telling people, well, it doesn't matter what you do. You can do whatever you want to rehabilitate yourself. You're going to be branded. You're going to be branded for your entire life because you won't be able to have your record suspended. This is a mark, if you will. And it isn't a brand, but it is a mark, the modern version of a brand. You're marking someone for life. And you're marking thousands of people. 3,800,000 Canadians have records, and about 32,000 are asking for pardons. And they're being told, well, be careful. You're going to have a mark because of this bill. And the mark will last your entire life, just as people were branded in the Middle Ages. And in a society of law that considers everyone's rights, this is unacceptable. When we talk about something that's ineligible, someone who's ineligible for a record suspension, this is the same thing. This is unacceptable. And the Bloc is against this, and we will be bringing an amendment which would abolish this entire part, that is, people who have been convicted of more than 3 indictable offenses with sentences of more than 1 year will be ineligible to have their records suspended. So this will affect all of the economic crimes as well. So don't forget, when someone's record is suspended, there's something very basic, something that we haven't discussed. Before suspending someone's records, you have to ensure that the person hasn't committed any other offenses. So someone who, no offense whatsoever. So you can't suspend someone's records if there has been a re-offense. So what does this mean? Someone who committed an offense, let's say in 95, for example, and then had to wait, say, 10 years to apply for a suspension. If, in the meantime, that person committed another offense, well, then it moves the deadline even further away, because he will have to serve his time for that second offense before asking to have the records suspended. So he might have to wait an extraordinary number of years and will eventually just give up. So the suspension of a record only works for someone who can be rehabilitated, someone who is a career criminal will never ask to have his record suspended. Why? Well, because he knows that he will reoffend, that he won't get a record suspension, that he is ineligible in any case. So this whole issue of suspending records or of pardons, who does it affect? It affects people who can be rehabilitated and who are already rehabilitated for all intents and purposes, because in view of the time that it takes to apply, in all of that time you've been able to prove that you are rehabilitated, that you haven't reoffended. So for offenses that are not serious offenses, this bill will target the 97% of those whose records have been suspended and who will never reoffend. These people will all be affected by this bill because the minister feels that it's logical. They don't understand the word rehabilitation. They are turning back towards the Middle Ages. I think what's important is that we take our time, that we hear witnesses, more witnesses, because I've submitted a number of names, so I think we should hear more witnesses. We should submit good amendments so that the bill will be effective and targeted. And what do we want to target? We want to target pedophiles. So let's target the pedophiles, not some woman who might have shoplifted so that she can feed her children, or some young fellow who made a mistake at the age of 18 because he picked a fight with someone outside a bar because someone else was trying to pick up his girlfriend. Let's target what should be targeted. We don't want pedophiles to have their records suspended. Let's do that, but let's do it properly. Let's target the right crime. We have to target the crime. And that said, Mr. Chairman, we will be bringing amendments, and I will be delighted to be able to contribute to making pardons for those who commit offenses against children ineligible. So I'd like to thank you for your indulgence, Mr. Chairman. I'd like to wish everyone a very Merry Christmas.
I have Mr. Davies and then Madam Mendez.
Well, thank you, Mr. Chairman. I know that we have a brief amount of time here. I just think that at the end of the day, before we take away the possibility of removing pardons from a wide swath of people for life, that we study the issue carefully and base our decision based on our best knowledge, best evidence, and the best understanding we can get. And having 120 minutes of testimony is simply not sufficient in this regard. I also just want to point out that I do want to hear from more victims groups. We did hear from two, and I thought that the perspective that they brought to bear on this was helpful. I noticed that the witnesses also testified that there's nothing in this bill that would provide for them being notified of someone making a pardon application or being aware of a pardon application happening, and that may be something that we as a committee want to look at. I think that's another area that we should delve into before we proceed hastily to rush this bill to pass for political purposes. So far, the only testimony we've heard is that lengthening the waiting periods for so many more crimes will hurt the rehabilitation process, and then that also in turn hurts community safety. And if it's one thing that we all share here together, Conservatives, Liberals, Bloc, and NDP, is that we all want to make our communities more safe. And while we may have differences on the best way to do that, one thing also I think we can agree on is that these are serious issues that Canadians are concerned about, and so they're worthy of our respectful treatment, and to make sure that we're making decisions and amending the law in a way that is way that's really going to help achieve that objective of making our community safer places. Mr. Chairman, I wanted to again mention that the minister himself, I think, to his credit, indicated that he was open to suggestions, and a couple of his quotes are that there are some circumstances in which, even for multiple offenders, we need to look at the situation. And he also said if this committee can find something that will address the concern of multiple offenders taking advantage of the system, it would be worthwhile for the committee to consider. So we have two clear indications from the minister himself that further consideration is not only beneficial but welcome. And I think that were wise comments on behalf of the minister, and that's why I think that we do need to have at least another couple of sessions so that we can make sure we hear from everybody, all the stakeholder groups, to have that consideration that the minister talked about, that I think is important before we change the laws of Canada. And once again, before we permanently take away the rights of people to have a pardon in this country, we should be doing that on the best evidence available and making sure it's good policy. Mr. Chairman, I see the clock is at 10:30. I don't know if we're going to be adjourning the meeting at this point, or what time do we go?
10:45.
10:45.
I have Madam Mendez
Okay.
on the
well, I have a couple of the
list too.
quotes that I would like to raise then, and that is about victims. Some of the testimony that we heard, and I'll quote, said this. In my experience working with victims, it is very important that the victims have an opportunity to understand what happened and why something happened. And they want to have some assurance that it's not going to happen again so that they feel safe. I think this is an important point. Ultimately, they want to know that somehow this incident has had an impact on the offender as well. They would like to know that the offender is going to be a better person or make some amends, not just to them but to society as a result. These are things I've heard when interviewing victims in mediation sessions, in preparing for mediation, and that I've come forward. I think actually what this bill would do is make it harder for victims to feel a sense of satisfaction, because they wouldn't get the sense that the person is moving on, that in being pardoned, the person has achieved a certain level, has met certain criteria, and has not committed a crime. I think that would be lost by this bill. Now, on the other hand, in fairness to some of the other victims that testified, they do support in some ways the thrust of this bill, and that's why I think we need to hear from more victims in this case. I also wanted to briefly quote, we talked about the offenders that came before this committee, and the kind of evidence that I'm talking about helps me as a legislator figure out what the best way forward is. And I'm going to briefly quote from that witness who testified, because this is the kind of evidence that I think Canadians need to hear more of. He said, "My name is Chris Corshane. I'm a member of the Sag King First Nation in Manitoba. I live in Winnipeg, and I'm a carpenter's apprentice. I'm here today to tell you my story and how it relates to the legislation being considered." That's 23B. "The first 11 years of my life, I mostly lived with my grandparents on reserve. I went to school, and it was a fairly functional environment. Then I turned 11. My mother did the best she could, but she suffered from having attended the residential school system. She was a drug addict and an alcoholic and was very abusive. This was her hurt. She wasn't able to look after me the way she should have had she had a normal upbringing herself. She got me involved with the local street gang when I was 11. My mother got me involved in a street gang when I was 11. The gang offered me belonging, opportunity, and safety. Between the time I was 11 and 24, I was arrested more than 7 times, and I have more than 7 offenses. I spent more than half of this time in jail, so that would be approximately 6 years. Every time I got out of jail, I had good intentions for starting a new life, but I continually hit dead ends, partly because I was unemployable with my history, partly because of alcohol and drugs. The cycle of offense, arrest, conviction, time in jail, and release would repeat itself over and over until I was 24. It was then that I was hired into a program called BUILD in Winnipeg's inner city. BUILD is an Aboriginal social enterprise that accepts people with backgrounds similar to mine, where we receive training, job experience, and a supportive environment. It helps us go from being unemployable to being an asset in the labor market. While at BUILD, I took a parenting course and realized the patterns I had to break in order to be a good parent to my 2 children. I took a budgeting course, WIMIS, first aid, and CPR, and even obtained my driver's license for the first time in my life through their driver's licensing program. Now I am ready to take steps to move on to my second apprenticeship level, but I can't do this with a criminal record. I am prevented from obtaining a good career job with employers such as Manitoba Hydro. I haven't reoffended now in soon to be 5 years, and I was intending to obtain a pardon, given that I will soon reach 5 years with no offense. I have now completed my grade 12, my level 1 apprenticeship, and my driver's license, as I said. I am a career-oriented and I'm a loving, committed parent to my 2 children. Prime Minister Harper offered an apology to Aboriginal peoples here in the House of Commons. When I heard about this apology, it encouraged me to heal and put the past behind me, and I look forward to becoming a productive citizen and member of society. I feel that the proposed legislation paints everyone with the same brush. I think that the pardon should be meant for people who clearly have demonstrated without a doubt that they have reformed and that they have a very negligible chance of reoffending. I know that with this legislation you are hoping to reduce crime. I think that is commendable. There have to be consequences for actions, but painting everyone with the same brush won't serve that purpose. I hope that you allow me to apply for a pardon. I'd like to move on with my life. That was the testimony from an offender who this legislation would prevent for the rest of his life from getting a pardon. And as you can see, Mr. Chairman, this is a person who doesn't have the typical life that a lot of children, we would hope a lot of children in this country have. Being put into a street gang by your mother when you're 11 who suffers from addictions, and being part of the street life as a young Aboriginal in this country is not exactly the kind of productive start that we want to give our children. By the time this young man was 24, he had more than the 3 convictions. Do we give up on him? Does this sound like a person who we give up on? A person who's turned his life around, who has taken the kinds of commendable steps that he's taken, finishing high school, doing an apprenticeship, not reoffending for 5 years, taking budgeting courses, first aid courses, CPR, trying to be a good parent to his 2 children. Well, this legislation that the government wants to push through quickly here would mean this person will never get a pardon for the rest of his life. And he's already explained, of course, like many Canadians would, how that would actually be a barrier to this person finishing his career. He actually couldn't finish his apprenticeship. Now, I also want to talk just briefly about public safety. And we heard this testimony as well. At most, only 4% of those pardoned reoffended at a later date, strongly suggesting that the current criteria are more than sufficient. A pardon doesn't prevent a person from being investigated for other offences or make it any easier for the person to commit a crime in the future. What benefit is there to public safety in doubling waiting periods and taking away pardons altogether from those who commit specific offences or have more than 3 indictable offences? On the contrary, putting additional pardon barriers in the way of individuals trying to move forward and live crime-free lives decreases public safety. It is in the interest of public safety and society that, once convicted of an offence, the individual has a way, a path, through the pardon process that's open to them, of putting their past activities behind them and not committing any further crime. There's also an element of unfairness in this proposed legislation for those it would most impact. It is well known that Aboriginal peoples are overrepresented in the correctional system. In Manitoba, Aboriginal people make up only 12% of the overall population, but represent approximately 70% of those incarcerated. These are the people who would be disproportionately affected and targeted by this proposed legislation if it's to pass. Now, Mr. Speaker, or Mr. Chairman, I'm sorry, maybe one day, Mr. Speaker. Mr. Chairman, we've heard that there are a number of sex offences in this legislation that would be put in the category of being unavailable for ever obtaining a pardon. And as I've said earlier, I think that there may in fact be indeed some sex offences that should never be pardoned. But we have not heard so far 1 minute of testimony from anybody who knows anything about sex offences. Or we haven't heard from any researchers or any therapists or any people in the correctional facilities, anybody from Corrections Canada, who I want to come to this committee and explain to us what the actual data is, what the expectations are, and what the real experience of those working with sex offences are. This summer, I went to the Regional Psychiatric Center in Saskatoon, and I sat and I talked to some of the very, very special people who work with sex offenders in that place. And of course, in the Regional Psychiatric Center, that is where sex offenders from the federal institutions who cannot access programs for various reasons are sent so they can get access to programming. And in that place, I sat and listened to a doctor explain to me that a number of these people were people who were illiterate, who had mental ages between 5 and 15, who simply couldn't access the regular sex offender programming. And in many cases, what she told me is that there is a vast, vast diversity of personalities and types of people when we talk about sex offenders. Again, we have some that perhaps are dangerous for their entire lives and should never get a pardon. We have others who actually are capable of rehabilitation and never offending again. Now, I don't actually know what the percentages are. I don't actually know how far we should go in this regard. But I do know this. I do know that nobody at this committee has any factual basis for making that determination, including myself, because we haven't heard from anybody. Now, I haven't made up my mind. I think as legislators, that's an important point, is to approach each of these subjects with an open mind. But surely, before we take away the right of a person to apply for a pardon for the rest of their life for broad categories of offenders, we should have factual basis before us. Now, I know what the Conservatives are going to do. For all the Canadians watching, they're going to run out and they're going to say, oh, the opposition says that people that are convicted of sex crimes against children should get pardoned. That's what they're going to say. And of course, that's not true. That is not at all what the opposition is saying. It's certainly not what I'm saying. What the New Democrats are saying is that we need to study this issue carefully because the truth is that there is a broad swath, a great diversity and range of people who are convicted of sex offenses. Some of the offenses that are in this legislation, I think, should be considered for prohibition against getting a pardon, particularly when we're talking about sex offense against children. But there are some offenses that are caught in here that are perhaps require some more nuanced thought. And I think that's things like some of the wide range of offenses in this legislation requires some study. Now, I want to hear from the Ministry. I want to hear from Corrections Services Canada. I want to hear from the people who actually work in our prisons and work with the offenders for all indictable offenses so that we can have the benefit of their testimony and their expertise. Because when they come to this committee, we pay them and we entrust the care of our offenders to these people who work every single day with offenders, our correctional guards, our prison psychologists, our social workers, our prison wardens, our parole officers, our people who work in halfway houses, people who work with offenders, former offenders themselves. We need that perspective to bear.
Mr. Rathgaber on a point of order.
Yes, as much as I'm enjoying Mr. Davies' eloquent expose as to why some sex offenders deserve pardons, it's 10:45, and I'd ask you to bring this meeting to a conclusion, Mr. Chair.
All right.
Point of order, Mr. Chairman. I mean, that characterization should be withdrawn. I did not say that sex offenders deserve pardons.
Okay.
I did not say that.
Thank you very much. I want to, first of all, thank all those departmental heads and all those other ones that were here and that were prepared to go on clause by clause. Thank you for your patience and your endurance to the end. I also want to just make quick mention that all witnesses that were submitted, all witness names that were submitted by the opposition and by the government were called on this committee, and I think that point needs to be on the record. And seeing the clock at 10:45, we are adjourned.